morning, everyone. I hereby call this meeting of the House Judiciary Committee to order. Mr. Secretary, please call the roll.
Representative Banta.
Present.
Representative Blanton.
Here.
Representative Bratcher.
Here.
Representative Bray.
Present.
Representative Burke.
Here.
Representative Dietz.
Here.
Representative Doan. Representative Flannery.
Here.
Representative Herron.
Here.
Representative Kulkarni.
Present.
Representative Lewis.
Here.
Representative Maddox. Representative Mosier. Representative Nemus.
Here.
Representative Petrie.
Here.
Representative Rawlings.
Present.
Representative Sharp.
Present.
Representative Stevenson. Representative Wilson. Vice Chair Decker.
Present.
Chair Elliott.
I'm here. And we do have a quorum, so we're duly constituted to conduct business. Are there any members who wish to recognize any guests before we begin? Vice Chair Decker, you're recognized.
I would like to welcome my first cousin, Jerry Ingram, who's here with a group today from Bardstown, Nelson County. It's a 4-H group, ages 9 through 17. So if you all will welcome them today. Thank you.
Welcome. Is there anybody else with any guests? So we have 6 bills before us today. An ambitious agenda, and the first bill that we will hear is House Bill 3, an act relating to human trafficking. Representative Suzanne Miles, who is the majority caucus chair, and if she would come forward and introduce herself and her guests introduce themselves, and you may proceed.
Thank you, Chairman Elliott and Vice Chairman Decker and members of the committee for hearing this bill today. I'm Suzanne Miles. I'm State Representative of the 7th District, and I'll let my guest introduce herself.
Good morning. Heather Wagers with the Office of the Attorney General. I'm counsel to the Deputy Commissioner of the Counter-Exploitation Office.
We bring before you today the bill about human trafficking. We did some human trafficking legislation in 2020, and we are trying to continue to advance that legislation to mirror what federal does and things like that to make sure that we can, to the fullest extent, penalize the people that are predating on all of our individuals that shouldn't be. This is... full disclosure, as far as I received a notice this morning that we will have to have a financial impact on this bill. So before that it could go to the floor, if we make it through committee today, we will have to wait on that. So they've identified, and we're assuming it's to mirror with the federal, it's what that is coming from. One of the other items I want to go ahead and bring up today is the National Human Trafficking Hotline. That number is 1-888-3737-888. We want to make sure that that number continues to get out there, and that was part of the original intent whenever we did in 2020 the legislation. I believe that was House Bill 2, to make sure that we have that number out there in all of our public transportation sites and things like that, so that if we have victims that are out there, they have the opportunity to see that number, and it's an easy number to remember in case they need help. Just to kind of go over a few of the things that are going to take place as far as the adjustments. Like I said originally, we are mirroring on the federal, on the first section. The next thing that we are adding into this is a working group under the Attorney General's office, and that is that he can create a working group of multiple items in this. I had spoken with Representative Herron last night. She had some input on a possibility of adding other groups to this list, and I'll work with her the possibility we may do a floor amendment to include that if necessary. Obviously, the Attorney General's office, I won't speak for them, but I do think that they will be very welcoming for the opportunities to add some things in as far as the different groups that are participating. The other thing that is probably most notable in this, originally when we did it, we did poster size that were to be displayed in all of the places, and those are a little bit cumbersome sometimes, and so we've come back and come with 3x3 films to be added, 8.5 by 11, or the 3x3 films that could be added to the mirrors in truck stop bathrooms, airport bathrooms, any of those places, with that to make it a little bit easier access to distribute that. Originally, we did not put any penalties for not complying with signage and things like that. We've given them 3 years for the opportunity to do that. Now we're coming back. They will get a warning the first time. Added in this bill, it'll be a $50 fine a day until they have something of signage out there after that in all the different public transportation places and things like that. So that's the kind of in a nutshell. I'll go ahead and defer to Heather if she has anything else that I've overlooked that she wants to add.
Thank you. Sex trafficking and labor trafficking occur in many different settings within the communities, and victims of these crimes have different experiences. So it is extremely important to have a holistic approach to this where everybody's input is valued and appreciated. And so I just am appreciative of the opportunity to work with the General Assembly, and I thank you all for having us here today.
There's a motion and a second. Is there any discussion? I think that there is. Representative Burke.
Thank you, Mr. Chair, and thank you to the sponsors. I think this is important legislation, and I'm happy to see it. I just wanted to ask one clarifying question as it related to the signage. Are those signs to be prepared by each place? So will hotels have different signs than bus stops will have different signs, or are they going to be standard so that they'll be recognizable from place to place?
In the past, that we've allowed them to do their own signage, but the information was provided from the Attorney General's office specific for that. We've had conversations, the possibility of working with Transportation Department to kind of have a uniform sign along with the information that has to be out there. It does have, as you can see, it does have on the signage for it to be in English and Spanish, so to make sure that we have a bilingual outfit to that. Would you like to add anything to that?
Sure. So the National Human Trafficking Hotline, as well as the Blue Campaign for Homeland Security, they already have a sign that you can order for free, so that's no cost. And so there's that option as well. And so we will provide one. One of the key important factors is that it's 8.5 by 11 for the poster, which means anybody can print it. The other one was, I believe, 11 by 14, which meant you had to go to a special print shop. And so we're trying to really give options.
That's wonderful. Thank you.
Representative Herron.
Thank you, Mr. Chair, and thank you, Representative, for bringing this bill forward. And we did speak yesterday about some of the things in the bill, and I completely support it. I just do have a little concern about the imbalance of I don't want to say power, but the imbalance of representation on the working group. I would prefer or like to see that potentially a victims advocate group would be able to co-chair this working group if it took place. I think that we have to make sure that we're always centering victims at all things that we're doing. And then my other question for you from the AG's office, I know that there, since 2013, there has been already a statewide human trafficking, I think it's called Human Trafficking Task Force. Are you all currently working with them or have worked with them in regards to this legislation, or how does that group fit into what the AG's office vision is for dealing with human trafficking?
The Attorney General's office is part of the Human Trafficking Statewide Task Force. There's many facets of that. We are, just like you said, you want to make sure this is a holistic approach. Victim service organizations are crucial and critical to this working group. And so I can promise that that will be the thrust of how this is approached, regardless if any language is filed, because we could not do our jobs as prosecutors, as law enforcement without them, as well as survivors. And so I know that Representative Miles got some insight into from the report that they issued, and that was some of the nexus for taking up their recommendations. So I see that going forward as a continued process, a conversation.
Ma'am, Mr. Chair, just thank you for that. And I do hope that we can potentially change language and to ensure that if this happens, that one of those groups would be able to co-chair. Thank you.
Representative Stevenson.
Thank you. It's not like this is my first time using this. I just have a question. What's the difference between the statewide and what this will provide?
It'll actually be an opportunity to kind of have a place that it would be housed. In fact, the Attorney General's office actually brought information to me yesterday, and that was part of it, this data report that they had brought to me and sent it to me. So I've looked it up this morning and kind of read through it a little bit more, and we're kind of mirroring some of the same things that we're wanting to do. It appears that this group, and I'm not familiar with this group, so I don't, other than what I've read online, I'm not as familiar with this group. And a lot of times as legislators, and the Attorney General's office is very aware when I reach out to them on issues like this. My question is, what do you all need from me as a legislator to help you all do your job better? And I think sometimes we kind of, sometimes that overlaps and sometimes it doesn't as far as that goes. So I think as far as the group that originally, I think it was over 10 years ago that the group kind of came together, and the way that I read on their site, it's kind of gone in and out. I think they continue to meet and things like that and make recommendations. But the only information I had was their report and a news article is all I really had from that. So the intent would be, if it's housed underneath the Attorney General's office, hopefully it'll be a collaborative effort of the victim advocacy groups. That was one of the suggestions they brought to me yesterday afternoon, that we might need to go ahead and add that in. And of course, Representative Herron also brought that to me. So I think that's a good opportunity. But I think it's one of those situations where sometimes we have groups out there and they're working very hard on items. But hopefully if we can kind of all work together with the legal field, the legislative field, and also all the advocacy groups out there, the healthcare workers, all of the victims organizations. That's another item that we just need to make sure that we collaborate together, and hopefully this will be an avenue that they can actually bring this legislation forward, make recommendations the way that we do through task force or working groups. Hopefully it'll be the same manner to make sure that we keep combating this as much as we possibly can, because this is not an issue that's going away. All we can do is hope that our state gets better at it.
I'll just add that the working group is co-chaired. That report is by Glenn Hardy and Marissa Castellanos. And in that, they recommend that there be a structure for identifying ways to share information within state government. So they are nonprofits pro bono giving their time to this, and this would be a way to kind of bring those systems together. So much data is housed in different silos across state government that this would be a way to move that. And so that is one of the recommendations.
Thank you.
Thank you.
Thank you. Is there any other discussion? I know a statistic or a fact that I learned a couple of years ago about human trafficking was that one of the most significant times of human trafficking was during the Kentucky Derby in an area of Louisville off I-64. So, after I heard that, it obviously hit close to home. So I appreciate your efforts here, and I know we've made efforts in the past, so I appreciate your effort to deal with this issue and bring more awareness to it, and to figure out what we can do to combat it effectively and to adequately punish those who are engaged in this activity. So there's been a motion, there's been a second.
And
Mr.
if
Secretary?
I may add
Yes.
just one more
Yes.
minor item to include in that thought process. The larger events are a huge target for human trafficking, no doubt. But another item is we've talked about homelessness a lot this session, and I think that opportunity, anytime that we have a child run away from home, things like that, a minor, that's one of the other items that is a huge target once they leave that home place and they're out there on the streets or wherever it may be. They are a huge target for human trafficking at that point too. So kind of keep in mind whenever we see the homeless people that there may be an opportunity there to check on them for that issue also. Mm-hmm. Thank you.
Thank you. Mr. Secretary, please call the roll.
Representative Banton.
Yes.
Representative Blanton.
Aye.
Representative Bratcher.
Yes.
Representative Bray.
Yes.
Representative Burke,
Yes.
Representative Decker,
Yes.
Representative Dietz,
Yes.
Representative Doan, Representative Flannery, Representative Herron,
Yeah, Mr. Chair, I'm a yes today, but I do hope that we can get that floor amendment done. Thank you.
Representative Kulkarni,
Yes.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie,
Yes.
Representative Rawlings,
Yes.
Representative Sharp,
Aye.
Representative Stevenson, Representative Wilson, Chair Elliott.
Aye. So with 20 yes votes and no votes, House Bill 3 is passed with favorable expression. So congratulations.
Thank you so much.
Thank you. The next bill that we will hear is my bill, House Bill 254, and I'll turn the helm over to Vice Chair Decker for her to take over the committee.
Chairman Elliott, will you please introduce those at the table with you?
Yes, I'm Daniel Elliott. I'm state representative for the 54th District, and I'll allow my guests to introduce themselves. They're well known to everyone here. But
Good morning. I'm Damon Preston, the public advocate.
I'm Scott West. I'm the Deputy Public Advocate.
Thank you. There is a committee sub. Is there a motion on sub?
Motion on the sub.
Second? Thank you. All in favor of the motion, say aye. Opposed? Committee sub is adopted.
thank you, Madam Chairman, members of the committee. House Bill 254 would bring some needed reform to the Department of Public Advocacy. And as we know, the Sixth Amendment to the U.S. Constitution guarantees the right to counsel for those who are indigent, and that was extended to the states through Gideon versus Wainwright in state prosecutions and felony offenses.
Madam Chairwoman, I can't hear the chairman speak.
I need to. Is that better?
Yes, thank you.
Where are you, Representative? Oh, you're in the back. I didn't see you. So just to recap what I had said earlier, the Sixth Amendment guarantees the right to counsel for criminal defendants, and we have to have a strong DPA. And this bill is some necessary reforms that we've been working on for a couple of years. Really, they precede my time as chairman. And to get into the specifics of the bill, I'm going to recognize Advocate Preston to go through the specifics of what this bill would do.
Thank you, Mr. Chairman. This bill is, we've had different versions of this bill in past sessions, and this is a scaled back version. But this is part of a larger plan, which we're working with A&R to hopefully get some funding for, but no funding is required by this bill. The main purpose of this bill is to give me the tools to respond quickly to the problem of turnover among public defenders. In the last 3 years, we've had very high turnover. In 1 year, we lost over a third of our lawyers statewide. At this moment, I have no doubt that somewhere in Kentucky, there is an indigent defendant standing charged with a serious criminal offense, and there's no lawyer in court with him today because that lawyer has resigned or has gone somewhere else, or we haven't been able to fill a vacancy. So, put simply, this bill gives me some additional tools to allow me to hire people quickly. This bill was filed and was considered far in advance of House Bill 6, but I will note that the version of House Bill 6 that passed the House and is currently sitting in the Senate would fund prosecutors' offices, Commonwealth attorneys, county attorneys with over $20 million of additional funds for higher salaries and for additional positions. The effect of that is going to be that many of those higher paid additional positions are going to be filled by lawyers that come from DPA, and I need to be able to respond to that quickly. And so all this does, the primary parts of the bill. Some of it are cleanup of language, but the primary policy parts of the bill are to allow me to hire the same way a prosecutor would, which is quickly without the 60 to 90 day wait that typically involves hiring in state government, and also to allow me to respond quickly to if someone comes to me and says the prosecutor is offering me $5,000 more to walk to the other side of the courtroom. Can you respond? I have no legal ability to respond within the merit system right now. This would give me the ability to do that. This is not a blank check in any way. I am bound by my budget, so I have to be wise. If I give people raises, that's going to cost me in another part of the agency. So this is not accomplishing anything to expand our resources. That will be done through A&R and hopefully a budget bill. This simply gives me the tools to be flexible when I need to be. I actually brought a little bit of a visual aid today. Many of you have probably seen this page. This is the LRC website that deals with the Kentucky Revised Statutes, this yellow page with blue ink. You've probably never noticed, but the Kentucky Revised Statutes are divided into titles. Title 3 is the executive branch. Title 4 is the judicial branch. If you look at this, DPA is actually listed under the judicial branch. We've never been in the judicial branch. You might wonder why that is. And the reason is because we're somewhat of a hybrid. I am accountable to a degree to Governor Beshear, to the Justice and Public Safety Cabinet, certainly to the Kentucky Bar Association, to the Public Advocacy Commission, but none of them can put me in jail. Today, in every circuit court, every district court, every family court in the state that's having a criminal docket, if a public defender doesn't show up, my neck is on the line to be show caused as to why we cannot provide the constitutional right to counsel that we are required by statute and constitution to provide. And so we fall between the judicial branch and the executive branch, and that's why we need to be a little more flexible. We need to be treated a little differently than the traditional executive branch office, and that's what's behind this. The one other policy change, if you look in this, the one other part that has a significant new language simply deals with the acceptance of fees by attorneys who are handling public defender cases. The current statute, as written, would actually criminalize and felonize under the current statute if one of our attorneys, I'll just Representative Flannery's a criminal defense lawyer. If Representative Flannery has a contract with us and is representing one of our clients, and another one of our clients, even by a different office, comes to his office and hires him, under the literal reading of the current statute, he would be guilty of a felony because he's representing a needy person under the chapter and is hired by a needy person at the same time. We need to clean that up. Not that this is a big problem. This has not happened, but it is some language we need to clean up. So that's the other significant policy change. Everything else, I'm happy to answer questions, but everything else, it really falls in the category of cleanup.
Thank you, Chairwoman. I just have a brief question. You talked about the different pay between the prosecutors and the public defenders. Can you just tell us exactly what that difference is? I'm just curious.
So we haven't studied this year. 2 years ago, we did a study, and the average assistant Commonwealth attorney and county attorney was making 17% more than the average assistant public advocate. This legislature gave us some money in 2022 to raise salaries. At the same time, prosecutors got additional money, so that I believe the gap is fairly consistent. And House Bill 6 provides additional money for salaries for them and does not provide it for us, so that gap's only going to widen in the future. Part of that is that prosecutors, county and Commonwealth attorneys are funded at 70% more than DPA. Their aggregate funding is more than us. We don't take into account the Attorney General's budget, even though they handle appeals and we handle appeals. So we do some things that county and Commonwealth attorneys don't. But that's the approximate difference. And then structurally, they have more freedom, so they can pay whatever market is in a local area, whereas I can't in the merit system.
Thank you.
Representative Nemus.
Thank you, Madam Chairwoman. I want to say off the top, thank you for bringing this bill, Mr. Chairman. Thank you, gentlemen, Mr. President, Mr. West. Very strongly support the public advocate in the role that you guys perform for our citizens. It's a crucial role. We need to, I think, make sure that we're trying to get more funding, especially in light of Commonwealth attorneys increased funding. And so both sides of the V need to be adequately equipped, both with resources and with the appropriate personnel to do the job. And so we need to do better at that. And I'm proud that we've been doing better at that, but we need to continue to do that. I do have a question about the bill that I didn't know was in there, and that's Section 2. I'm concerned, I may be misunderstanding this, but I'm concerned about mission creep. And the way I read this, correct me if I'm wrong, is that we're establishing a new division under the public defender to effectively enforce disabilities rights. That's very important, but doesn't seem to be the role of the public defender. So help me understand that better.
Yeah, there's no policy change there. This is the deleted language under Section 1. The sole purpose of Section 2, and I'm glad you asked, Representative Nemus, the sole purpose of Section 2 is to separate that statutorily, because Protection and Advocacy Division, which is federally funded and under a federal mandate and structurally already a part of DPA, that they have made a proposal to spin out of DPA to become a nonprofit, which is the structure in most states for that federally mandated service. And so this will make it cleaner when that is done for them. We'll simply repeal that statute at that point, and that'll be done. No policy change, no funding change, no mission change is reflected here. They're already a part of DPA. This simply makes the language cleaner so that later, when they're not in state government, that we'll simply repeal that.
I'm satisfied with that. Thank you.
Thank you. Representative Flannery?
Thank you. I guess this is a follow-up to Representative Nemus, and I think you answered the question, but is it your all's position that you're okay with that spinoff, that you want that to happen, or what is your all's position on that?
The way I've always looked at it, Representative Flannery, is DPA is independent within the Justice Cabinet. We're attached, but we're independent. P&A is independent within DPA. They have a federal mandate. I cannot interfere in their mission. And so I leave it to, they have a board and a council and a federal mission, and a director of P&A who is a part of our agency, but again, independent. So I guess my official answer is I don't take a position on it, because the public advocate position is the administrative head of the director of P&A, but my job is to worry about the Public Defender Service of Kentucky, and they are not a part of the public defender mission of DPA. Simply when this happened in, I think under Governor Carroll in 1979, they had to put P&A somewhere, and they put it in DPA. And we're happy to have them. We work with them, but I don't make decisions as to P&A.
Thank you.
Representative Banta?
Yes, would this in any way encourage or you guys to take people that aren't poor anymore? You can take any case that you want?
It's not intended to do that. The appointment language is always the same. If you're referring to in Section 1 where we change it from indigent to eligible, the only reason we do that is because Chapter 31 already anticipates that we take some people without a determination of indigency, specifically juveniles. A court can take a parent's income into effect, but they don't have to. So there are some very limited circumstances where indigency is not a requirement. Tim's Law, Casey's Law, or other areas like that. So that was simply to reflect that not literally every client we have is indigent, but this is not, we don't change any language as to what cases can properly be appointed to us.
Okay, thank you.
I don't see any other questions. There's been a motion and a second. Oh, okay. Representative Wilson.
Yes, so as you know, I worked with DPA. I had a confused client one time try to pay me, and I guess she was referring to the attorney's fees ordered by the judge.
Sure.
Have you had any cases of people actually employed with you taking money from these indigent people? I mean, these people do not know how the system works. I understand the example you gave with a contract attorney being hired who's also private. I understand that, but what about the folks that are not for private hire, that do not have their own law practices? Have you ever seen any employees take extra money from these indigent poor people?
I'm not aware of anyone that has accepted money. I'm very aware and have personal experience with being offered money from a client that knows that a public defender's time is very limited and says, if I pay you a little extra, can you spend more time on my case? That is something public defenders face. I'm not aware of anyone that's accepted that offer. If they did, it would certainly be a violation of the statute before you. It'd also be an executive branch ethics problem and a KBA problem and a DPA problem. So we would take that very seriously. But I'm not aware of any, and I'll defer to Scott, who served as general counsel for a while. Any actual examples we have?
Not in the past 25 years. Before my tenure at DPA, I had heard lore of someone who had done that, and they were immediately dissected away from DPA. But one thing I will say about this, and we have had people who, because of the ambiguity that Mr. Preston described, don't really want to take a conflict contract because they're afraid that somebody else who may be appointed to a DPA person but wants to hire, and the family now has raised the money, they're afraid to take the case afraid to take a conflict contract because that might prevent them from being able to accept fee cases, and we do not want to take fee cases away from private attorneys.
Thank you.
Okay, so we've had a motion, second, no more questions. Secretary will please call the roll.
Representative Banta.
Yes.
Representative Blanton.
Aye.
Representative Bratcher.
Yes.
Representative Bray. Representative Burke.
Yes.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Doan. Representative Flannery.
Yes.
Representative Herron.
Yes.
Representative Kulkarni.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
Yes.
Representative Mosher.
Yes.
Representative Nemus.
Yes.
Representative Petrie. Representative Rawlings.
Yes.
Representative Sharp.
Aye.
Representative Stevenson. Representative Wilson.
Yes.
Chair Elliott.
Aye.
With 18 yes votes, 0 no votes, and 0 pass votes, House Bill 254, as amended by the committee sub, is passed and will be reported as with favorable expression that it same should pass on the floor. Thank you. Thank you all for your
committee.
presentation.
Are you sure you want me to take back over? Oh, goodness. Oh, my. So, where's the agenda? You want to do that one next? Okay. Senate Bill 70. Senator Wheeler, if you'd come forward. Where's my script? Is that?
Thank you very much, Mr. Chairman. It's an honor to appear before your committee.
You're recognized, and you may proceed, Senator.
Thank you, Mr. Chairman. Senator Philip Wheeler, 31st Senate District, Pikeville, Kentucky. Senate Bill 70 is a very simple little bill. It's the Donor Intent Protection Act. The purpose of this bill is to simply protect charitable foundations and individuals who donate large amounts of money to charitable institutions to make sure that the intent of the original gift is adhered to by giving them standing to sue in circuit court to obtain an injunctive order to get the charity to comply. Clearly, we want to encourage people to donate money to charitable institutions, nonprofits, universities, etc. But we feel that a donor is more likely to do that when they have the knowledge and the assuredness that if the charity or university, etc., goes off the rails as far as the intent of the gift, that they have a right to go in and seek redress. What's important about the bill, it does not require a refund. It is only injunctive relief to force compliance. So what happens is, if they determine that the charity is not complying with the terms of the original gift and the donor intent, it has to be in writing. then the person would have to notify the charity or the university of what the violation was. It gives them an opportunity to remedy, and then if they're not able to do that, they can take action in court to ensure compliance. It's merely a bill to strengthen the bonds between donors and their charities in the Commonwealth of Kentucky by providing those assurances and giving them peace of mind, and that's essentially the bill.
There's a motion and a second on the bill. Is there any discussion? Seeing none, Mr. Secretary, please call the roll. Oh, there is. I'm sorry. Representative Burke.
Yeah.
Thank you, Mr. Chair. My question relates to the Uniform Prudent Management of Institutional Funds Act. Could you explain for us why the UPMIFA is insufficient to protect endowment funds, and how this bill would improve on the current state of the law?
Certainly. Frankly, the reason being there's uncertainty in the law. And, in the Commonwealth of Kentucky, it is not clear from a legal basis whether a person has standing to actually enforce in court. There has been a patchwork of decisions across the United States in differing jurisdictions that say that some people will hold that the donor has standing to enforce the gift. Others say that the fact that it is a gift, once the gift is given, the donor essentially relinquishes control over that. So what the purpose of the bill is essentially to clarify that a donor does have standing and does have rights within the Commonwealth of Kentucky.
Did the Uniform Law Commission participate in the drafting of this bill to help it achieve a uniform outcome?
No, Representative Burke, I did not meet with the Uniform Law Commission, but they've expressed no opposition to this particular bill.
And one final follow-up.
Yes, please.
It's my understanding that the Kentucky Nonprofit Network is not a fan of this bill. Have they expressed that to you as well?
They have expressed that to me, and frankly, the concern that they've expressed to me was that it would cast doubt on the good work that nonprofits are doing. I think quite the opposite, that this would, in fact, strengthen the resolve of donors to contribute to these organizations if they know that they have a right to enforce the terms of their gifts. So they have expressed that concern to me. I do not feel that it is a valid one. I mean, I think every bill that we pass down here has some group that is affected, and to say that we would cast doubt on anybody anytime we pass a bill is just simply not a valid concern.
Thank you. As a member privately...
Thank you. Are you seeking further recognition?
Yes, thank you. I'll make a brief comment. Thank you, Chairman.
Go ahead.
As a member of the Kentucky Nonprofit Network, I do also find concern with this bill. I'm not familiar with any issues in Kentucky that would lead us to the need of this particular bill, although I'd be happy to be informed on a situation in Kentucky where this would be needed. But it seems to me that by creating endowments, there are very specific directions of how those are to be used, and not being familiar with any straying from those kinds of prescriptions, I just don't find that this is a useful piece of legislation. Thank you.
Representative Herron.
Thank you, Mr. Chair. I just have one question. Can you provide an example of a situation in which the intent may have been violated, or has there been something recently that has happened that you are aware of that is the premise for this legislation?
Well, since you asked, the J. Graham Brown Foundation, which is the largest charitable organization in Kentucky, now I will say that bridges have since been mended, but there was a period of time that they had a strained relationship with the University of Louisville over some mismanagement of funds in their endowments. You may remember all the issues with President Ramsey and some of the Board of Trustees that were serving on there misusing funds. That has since been resolved. They are, again, cooperating with the University of Louisville, but that would be probably the most prominent example in Kentucky where the lack of adherence to donor intent has resulted in a suspension of funds. Yeah.
Thank you, Mr. Chair.
Representative Stevenson.
Ask the thank you, asked a question concerning the reach of the bill. So, for example, if a nonprofit bail's organization released a person that committed another crime, could the people who donated to that nonprofit ask for some type of judgment under this bill?
Okay, I'm sorry, I don't
Well,
quite follow the question. I apologize.
Oh, no, I haven't had my coffee either. I'm just trying to understand the reach of this bill. Does it apply to small nonprofits too? And the one that comes to mind is the bail organizations that oftentimes bail out people accused of crimes. Some of those people have committed other crimes. Could they say you bailed out the wrong person?
No, I don't believe so, Representative Stevenson. I mean, clearly this is merely injunctive relief. There's no judgment obtainable here, so I mean it is specific performance, as you're well familiar with. So no, this bill would not condone that.
Thank you.
Also would not, if a person were successful in pursuing a claim, a donor or an organization that donated the funds, they would not be able to recoup any funding from the charity.
Absolutely correct, Mr. Chairman.
Yeah. Yes, Vice Chair Decker is recognized.
Thank you for bringing this. I think it is necessary. I think it's a good thing. I think it will do the opposite. Put it on. I think it will do the opposite of making people worry about nonprofits. I think it will cause donors to have a sense of safety with this. I run a nonprofit. I voluntarily have an audit every year because I want people to know that when they restrict donations, they are shown as restricted, they are kept. Also, the BBB looks at things like that, and I think donors are afraid that their donations will not be used as they desire, and this bill will only strengthen the fact that that should not happen in Kentucky. So I appreciate you bringing the bill. Thank you.
Thank you, Representative.
Representative Kulkarni, you're recognized.
Thank you, Chairman. I just had a quick clarification.
Mm-hmm.
This is only applicable to endowments, correct? And endowment agreements?
Well, it would apply to nonprofits and specific, yes, it is contractual endowment agreements, correct.
Okay, thank you.
There's a motion and a second. Mr. Secretary, please call the roll.
Representative Banta.
Yes.
Representative Blanton.
Aye.
Representative Bratcher.
Yes.
Representative Bray. Representative Burke.
No.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Down. Representative Flannery.
Yes.
Representative Herron.
Pass.
Representative Kulkarni.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
Yes.
Representative Mosier.
Yes.
Representative Nemus.
Yes.
Representative Petrie. Representative Rawlings.
Yes.
Representative Sharp.
Aye.
Representative Stevenson.
No.
Representative Wilson. Yes. Chair Elliott.
Aye. Representative Stevenson, would you record your vote? We didn't hear you. I don't think it was my microphone.
No.
Thank you. So with 15 yes votes, 2 no votes, and 1 pass vote, your bill has passed and should pass the floor with favorable expression. So congratulations.
Thank you very much, Mr. Chairman.
The next item on our agenda is House Bill 626, an act relating to interference with a legislative proceeding. Representative John Blanton. you're recognized, and if you'd introduce yourself, and you can begin, sir.
Thank you, Mr. Chairman, members of the committee. John Blanton. I'm representative for the 92nd District. May I begin?
Please
Thank
do.
you.
Please do. Yes, sir.
The purpose of House Bill 626 is to ensure that the General Assembly has an opportunity to legislate without interference from people who wish to prevent us from doing our work on behalf of our constituents. There is nothing wrong with protesting and attempting to make your voice heard. Protesting is as American as apple pie. But when you prevent a legislative body from doing its work, you cross a line. House Bill 626 was drawn up with 3 specific scenarios in mind. First, when you physically obstruct or impede a legislator or legislative employee's ability to go into a room or go from one room to another with the intent to prevent the General Assembly from conducting business, you cross a line. Class B misdemeanor, it would be a Class B misdemeanor for the first offense and a Class A misdemeanor for the second offense. Second, when you enter into a legislative chamber or a room that is set aside for use of legislators or refuse to exit with intent to prevent the General Assembly from conducting business, you cross a line. This too would be a Class B misdemeanor on the first offense, Class A misdemeanor on the second offense. Third and finally, when you engage in disorderly or disruptive conduct inside a legislative building and you actually prevent the General Assembly from conducting business, then you've crossed the line. First offense would be a Class A misdemeanor, and the second offense would be a Class D felony. I believe it is important to enact statutes tailored to deal with this issue instead of simply relying on the more general offense of KRS 519.020 for obstructing government operations, which seems more appropriate for an attempt to prevent an executive branch agency from doing its work. And this is a Class A misdemeanor currently, and you'll notice most of these that I'm bringing are Class B misdemeanors for first offense. And in our judicial branch, judges have the power to deal with interruptions in the courtroom by use of criminal contempt proceedings if necessary. This bill simply provides an equivalent protection for our legislative branch. That's what this bill does, Mr. Chairman. I'd be glad to answer any questions.
Thank you, Representative Blanton, for the presentation, bringing the bill. You know, we have to operate under the rule of law in our society, and this is just another step in that direction. And we have seen, unfortunately, efforts to interfere in legislative proceedings in our state, seen it across the country. I know in this committee, maybe 2 years ago, before I was chairman, we had a discussion in the interim about threats to legislators and issues that had arisen, unfortunately, across the country. Obviously, we want everyone who wants to express their views to do that in a peaceable, civil manner that's allowed under the First Amendment, as you've pointed out. But we also have to have the ability to conduct the people's business without interference in a way that prevents us from doing that. So I'm supportive of your bill. Is there any discussion amongst the membership? Representative Herron, you're recognized.
Thank you, Mr. Chair, and thank you to you, Representative Blanton. I mean, I do have a little concern with this bill. I mean, yesterday we just celebrated year anniversary of the March on Frankfurt, and Dr. Martin Luther King Jr., Jackie Robinson, and some others came to Kentucky to pretty much march and say, you know, we need to make sure that we're passing a Civil Rights Act here in the state. But I also know that there was times that groups such as Dr. King, that they would use civil disobedience to have a point. And I believe that, I think that sometimes it's a fine line. As a legislator, I have sometimes felt unsafe, get stared down in committee if you don't vote the way somebody wants you to. And I'm thankful for our KSP that they're in the hallway so I can go to the restroom and get back to committee, so that the safety of legislators is very important to me. However, I am just concerned with something like this because I feel like that, as you mentioned, the other statute, but then also disorderly conduct, I feel like would be appropriate. So I guess I've always said that I don't like creating more codes, and that's one of the issues for me. So I guess my question would be, would the other statute that you mentioned, as well as disorderly conduct, would that not be sufficient for if someone was to come in to committee right now and disrupt?
Thank you, Representative Herron, for your question. Very good question. Fully supportive of people's right to have their voices heard and protest. It was a significant day for us, and because of the work of Dr. King, I mean, he's brought us leaps and bounds from his days. We still have a distance to go, but it got us started in the right direction. Everybody has the right to have their voices heard. Not trying to impede that at all. You know, and your question is, would these other statutes be applicable? Well, we have some attorneys on this committee, and we find in law sometimes it's debatable. Yes, depending on who you're talking to, right? Will this apply? No. Well, we want to say, yeah, it does apply. So all I'm trying to do is put into language certain protections for the legislative body, not to prevent free speech, not at all. I wouldn't be for anything like that, but simply to provide protections that keeps us from the General Assembly for someone who is intentionally trying to prevent us from carrying out our responsibilities and doing our jobs and providing what our constituents sent us here to do. So looking at it from a practical standpoint, it's just another tool for law enforcement that's specific to the General Assembly and the LRC employees, that we have protections in place. I hope that answers your questions.
Yeah, thank you, Mr. Chair. Thank you.
Thank you. Representative Bratcher.
Representative Blanton, is there anything in the law that you, during your research, that you can come after the person that's organizing it, kind of like they're going after Trump right now for insurrection, quote unquote insurrection, whatever it is? Is there people, the higher ups that organize this, is there any way to go after them?
Well, first of all, this has nothing to do with Mr. Trump, but if you read in Section 1 under definition, there is a definition for conspiring and for facilitating these type of activities.
Well, I think a lot of the recent protests here at the Capitol were organized by hires, and it seems like they should be the ones being answered for this. So anyway, that was just my thought.
Representative Stevenson.
Thank you for this, and thank you for your stand that the principles of democracy should be followed, freedom of speech. My question is this: last year, we actually had a disruption when we were passing SB 150. There was a lot of noise in the chamber, and those people were escorted out and some were arrested. We had some authority to do that at that time. Do we not have that authority? I know you want to be sure, but we were pretty clear that to continue our business.
So very good question, Representative Stevenson. And it goes back to that definition of, does the statute of 519.020, is that applicable? I believe that was probably what was utilized last year. This just puts it more plainly so that our troopers will have that. And if you'll recall, unfortunately, and again, those people had the right to have their voices heard, but it stifled our ability on the floor to be able to have debate, which is healthy as well, right? We got cut off and got shot right to a vote. And so it impeded our ability to do the work of our constituents for people who wanted to get up regardless of what side of the issue they was on and have their voices heard. So it stifles our voices to some degree. So this just, in a practical manner, clarifies it so that the troopers that are working have something to go by that is not debatable. Does this apply or does that not apply? I hope that answers your question.
One more question, please.
Yes, please.
So in the case, oftentimes when we're in session, there are a lot of groups in the, I don't know what the place, the rotunda, and we can hear them in session. Who decides who should be arrested and who should be put out of the Capitol? Like if it's bothering us but not the Senate, who's the decision maker?
Thank you. Good question. First of all, this has nothing to do with bothering someone, okay? This has to do with, for the purpose of from allowing us to complete our duties. That's it. So if they're down the rotunda and they're being loud, I trust our troopers to make decisions. Let's use this room in a committee meeting as example rather than rotunda. If we had someone come in that was being really disruptive in here, the chair would ask them to leave, right? If they refused to leave and they continued in a manner that kept us from being able to move forward with our legislation, our hearings, then the chairman would call for security or a trooper to come in. They would ask them to leave, you know, and if they refused to leave and continued with the intent, keep in mind that word intent, to disrupt us from being able to do our jobs, to have our hearings, then and only then could somebody be charged with a misdemeanor, a Class B, which is the lowest level of misdemeanor that we have.
Thank you.
You're welcome.
Thank you, Representative Kulkarni.
Thank you, Mr. Chair, and thank you for your presentation. I have some significant concerns around our constitutional right to peaceably assemble. And my question is, you know, we're talking about law enforcement. This is a tool for law enforcement to use. How, if we have a group of people, not talking about an insurrection, not necessarily talking about people being intentionally or, you know, objectively intentionally disruptive, you're talking about knowingly engaging in, you're talking about intent. How is a law enforcement officer in a large group of people that may, for instance, be at the bottom of the steps leading up to the chamber, how would an officer distinguish intent of one person versus somebody that's in that group? I think that there would be, you know, there's a lot of opportunity for confusion when you have large gatherings of individuals who are, you know, using their constitutional right to be in the people's house. So I wanted to ask how, or if there are any guardrails that you see in this particular legislation that would allow a law enforcement officer to be clear on a person's intent when they're part of a large group that's assembled and isn't necessarily being overtly disruptive.
Thank you, Representative Kulkarni, for your question. First of all, let me key on your first comments leading to your question. Peaceably assemble. Now we get into interpreting what is peaceful and what is not, correct? As far as them being at the bottom of the stairs and going up, with the statute that has been used in the past, it's no different with this than it was with that statute to determine. As a matter of fact, their first course of action is going to be to go to the area where the disruption may be, and they're going to observe. And if they can identify, they're going to ask them to leave. And then if they don't, they're going to try to identify. They're not just going to go up there and randomly start arresting people. We've never seen that happen here. And I don't believe that these young men out here and women in the gray uniforms are that antsy. I don't think it's they're wanting to remove people, but they are wanting to make sure that we're safe here and able to do our jobs.
Brief follow-up, Mr. Chair, or Mr.
Yes,
thank
you may.
So just for clarification, if there is a large group of people that might possibly be physically impeding legislators, or it could be interpreted on physically impeding legislators from going up the stairs, would that be interpreted under this statute as being disruptive or impeding our ability to do legislative?
It could be if they are impeding our ability to move from one room to the next, not only ours, but our LRC staffers, if they prove the intent is to prevent us from getting there to conduct our business. They have to be able to prove intent, and that lies upon law enforcement to prove intent.
Thank you, Mr. Chair. Thank you.
Thank you. Representative Moser.
Thank you, Mr. Chairman. Thank you for bringing this bill. This is a good conversation. I appreciate the intent, and I'm wondering if it looks like this needs to occur on the physical premise of our campus to apply. Is that correct?
That is correct.
So threats wouldn't really be covered in this.
No, ma'am.
Veiled, I know where you live kind of threats.
No, ma'am. One
which
could,
I've had.
again, go back and debate statute, but we have terroristic threatening statutes in place that's applicable to all citizens, including us as legislators.
Okay, thank you.
Representative Burke.
Thank you, Mr. Chair. Rep. Moser just asked one of my questions, so I thank her for that clarification. I was thinking about the bomb threats that we and other General Assemblies had received earlier in this year, which clearly were an intent to impede our work. And I think you've also clarified my other question regarding intent and whether or not the intent is necessary in all portions. And if I'm understanding you correctly, we need to be able to prove intent not only to disrupt, but also intent as it relates to conspiring, facilitating, and impeding. So the intent flows through, is that correct?
That is correct.
Thank you.
Thank you very much. We have two individuals who have signed up to speak in opposition, and I do want to recognize them for some time. Michael Frazier and Rebecca Blankenship, if you would come forward, and you can have some time to discuss why you're opposed, and then if any members have any questions or comments of them, we'll take those at that time.
Yes, thank you, Mr. Chairman, Madam Vice Chairwoman, and members of the committee. My name is Michael Frazier, and I'm the Executive Director of the Student Rights Coalition, where we protect students on our college campuses, both public and private, to speak freely, think freely, express freely, and believe freely. And this is my colleague, Rebecca Blankenship. I do want to clarify that we're not necessarily opposed to this bill, but we do think that we actually have some stronger language and perhaps a bit of a cleanup language to help to assist the bill. Because a heckler's veto, which is where somebody intentionally uses the force to conspire to disrupt a presentation, speech, or the members of this General Assembly, is not protected underneath the First Amendment. That is a heckler's veto. And that's something that we strongly believe in and something that we incorporated in this body in 2019 in HB 254 that was passed by the good woman from Grant County, Representative Savannah Maddox. So we do have an issue when it comes to heckler's vetoes here, and we do have a compelling state interest so long as we narrowly tailor the matter to ensure that heckler's vetoes do not perform either on the floor or at the door or in true threats here at the General Assembly. But there are points of the bill of where that there could be opportunities to make it stronger to ensure that we protect the constitutional rights of all Kentuckians. In the first section, when it comes to labeling the conspire, and Rebecca, would you like to take it?
Sure. So I'm Rebecca Blankenship. I'm assistant. I don't know if my mic is okay. Here we go. I'm Rebecca Blankenship. I'm assistant executive director of the Students' Rights Coalition. And I want to echo, of course, Mr. Frazier's suggestion that this bill is intent is constitutional in nature. The General Assembly obviously has a compelling state interest in ensuring that it can conduct its business. And so what we would just want to make sure is that nothing is captured that is not intended to be captured by this legislation. So particularly as Representative Stevenson was asking questions about a minute ago, is Section 2, subsection 1, and Representative Burke alluded to this as well, that word knowingly that occurs at the beginning of that clause does not clearly apply to every phrase in there. There's more than one way to fix that, but just ensuring that we're not capturing unintentional behavior. You know, I think about my grandpa. He never ever wore his hearing aids, and he had blasted his hearing when he was in the National Guard by never ever wearing his earplugs. I guess he just didn't like stuff in his ears, but he would talk loud at church. And, you know, and I think about somebody who's unintentionally maybe being disruptive to the General Assembly, being accidentally captured by the way that this is currently written. And then, of course, as somebody else alluded to, the rallies and the rotunda can get a little bit rowdy. You know, we wouldn't want a rally shut down that is being unintentionally disruptive versus a protest that is clearly intended to disrupt the business of the General Assembly. So I think that there's more, that the correction to that can happen more than one way. And our sincere apologies to the bill sponsor for having not asked for a meeting before this. We really just became aware of the bill quite recently. So it's our
a lot going on this session.
So it's our intention, you know, we're supportive of the bill and just really have those critiques, is that correction of knowingly.
And particularly, we also want to encourage the bill sponsor that when it comes to construction, that there is opportunity to define it, to just better hone in to ensure that we don't create a constitutional vagueness situation with the bill. So we do appreciate you, sir. It is a good bill. There's just some opportunities for us to find and ensure that we complete our state interest to protect the members of the General Assembly, ensure a heckler's veto doesn't come, and we don't get into vagueness issues or overbroad that gets into protected speech issues too. So thank you all, and we appreciate the honor and opportunity to be here today.
Thank you for your comments. I move for adoption. Is there a second? There's a second. Mr. Secretary, please call the roll.
Representative Banta.
Yes.
Representative Blanton. Aye. Representative Bratcher.
Yes.
Representative Bray.
Yes.
Representative Burke.
Pass.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Doan.
Yes.
Representative Flannery.
Yes.
Representative Herron.
Pass.
Representative Kulkarni.
Briefly explain.
Yes, please.
I'm a pass for today. I would like to continue some discussion with you about tightening up some of the language to address some of the concerns I've heard today. Thank you.
Representative Lewis.
Yes.
Representative Maddox.
Briefly explain. Mr. Chairman, I appreciate the opportunity to explain, and I appreciate you bringing the bill, Representative Blanton. I'm voting yes today because I understand what you're trying to do here. I understand that it's necessary. If there's any aspect of this that could possibly cause people who are organizing events to have any liability for the bad behavior of others, I don't know if that's possible or not, but if it is, you know, some of the concerns have been voiced here today. Take a look at that, but otherwise, I'm a yes. Thank you, sir.
Representative Mosier.
Yes.
Representative Nemus.
Yes. Well, thank you.
Representative Petrie. Representative Rawlings.
Yes.
Representative Sharp.
Aye.
Representative Stevenson.
Briefly explain.
Yes, you may.
I would appreciate you bringing the bill, because we need to be able to be safe in the space where we're doing the people's business. And I want to pass until we can figure out how to make sure we are not infringing upon the constitutional rights, and we know exactly how it's going to be triggered.
Representative Wilson.
Yes.
Chair Elliott.
Aye. So with 16 yes votes, no votes, and 4 pass votes, House Bill 626 is passed with favorable expression that the same should pass to the House floor. Congratulations, and thank you, Representative Blanton.
Thank you, Mr. Chairman. Thank you, members of the committee.
The next bill that we will take up is House Bill 619. Representative Nick Wilson. an act relating to terms of imprisonment. I'll recognize Representative Doan. I know you came in, so you can record your votes at this time.
Thank you, Mr. Chairman. I'd like to record my attendance as well as a yes vote on House Bill 3, a yes vote on House Bill 254, and a yes vote on Senate Bill 70.
So recorded. Thank you.
Thank you.
And you're recognized, Representative Wilson. If you'd introduce yourself, and your guest can introduce herself, and you can proceed.
Thank you. I'm Representative Wilson, District 82, Whitley County and Laurel County.
Good morning, and thank you, Mr. Chairman. My name is Amanda Morgan. I am currently a prosecutor with the Special Prosecutions Division within the Attorney General's Office, and prior to that role, I was a prosecutor at the Fayette Commonwealth Attorney's Office for 6 years.
Thank you. I'm here today presenting House Bill 619. It's a cleanup bill that addresses two sentencing statutes that are in conflict with each other. Was really brought to everyone's attention by a Supreme Court opinion last year, Kimmel versus Commonwealth. And actually, really, in the opinion, the Supreme Court basically pointed out this is something the General Assembly needs to fix. But basically, KRS 532.110, it refers to the PFO statute, which states that the max sentence for a Class D or Class C felony is 20 years. Of course, one act is 1 to 5 years, so this is talking about multiple sentences on multiple crimes. However, KRS 533.060 provides that sentences for convictions while on parole, probation, or while awaiting trial shall run consecutive. So there's a bit of conflict between what is the max versus how do these sentences run concurrent or consecutive. I have someone with the Attorney General's office today, Amanda Morgan. Do you have any, I guess, examples of the unintended consequences of the Kimmel opinion?
Sure, thank you. So Kimmel dealt with burglary third degrees and theft charges, but practically across the state, what we are seeing and what I saw in Fayette County as well is when you have someone charged with D or C felonies, and those may be, for example, C felonies that are sex crimes or significant drug trafficking, not just the under 4 grams, but the significant drug traffickers that are dealing in over 100 grams of meth or something like that, significant amounts of fentanyl. It incorporates your robbery second degrees, your assault second degrees that may be stabbings or non-fatal shootings, where luckily the victim has suffered a physical injury but not a serious physical injury. And so what Kimmel does is it hinders the ability of prosecutors to not only do our job of trying to hold people accountable who are committing crimes when released on bond time and time again, but also keeping our community safe.
And really what we've run into is people committing felonies and getting no punishment at all. So the Kimmel case specifically, there was, well, I'll just say, for example, if someone committed multiple burglaries over the course of this weekend, say they committed 5, 6, I mean, it happens. Those are Class D or Class C felonies. Even though it's 1 to 5, even 5 to 10, if a jury wanted to give them 80 years for the 8 crimes, it would be capped at 20 because it's all one occurrence, one string of events. What Kimmel says is if that person, and this is basically what happened to Kimmel, if that person does that, goes to prison, is let out on parole, and commits another burglary, years later, they've already maxed out. So there's no new penalty for the new crime.
There's a motion and a second. Is there any discussion? Representative Herron.
Can you just go back and explain that last piece that you said? That
Sure.
Yeah.
So in Kimmel specifically, a man was arrested for burglary, charged, indicted, let out on bond, was arrested, charged with another burglary. The jury gave him, after jury trial, gave him 40 years. The Supreme Court said, well, under the PFO statute, the max is 20. However, and this would be 533.060 subsection 3. The man, so Kimmel, was awaiting trial. And so we have a statute that says, for something committed while awaiting trial shall run consecutive. However, in this case, it's not able to run consecutive because it goes over the max in the Kimmel case. So I think our intent of, yes, C's and D's are maxed out at 20 years. I think that's a good law that we're not trying to change. It's just if someone is on parole, probation, or awaiting trial and commits new Class C or D felonies, then that sentence shall run concurrent or consecutive, regardless of any max or cap. I hope I was able to explain that.
Thank you. So seeing no other discussion, Mr. Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton, Representative Bratcher,
Yes.
Representative Bray, Representative Burke,
Pass.
Representative Decker,
Yes.
Representative Dietz,
Yes.
Representative Doan, Representative Flannery, Representative Herron,
A pass.
Representative Kulkarni,
Pass.
Representative Lewis,
Yes.
Representative Maddox, Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie, Representative Rawlings,
Yes.
Representative Sharp,
Aye.
Representative Stevenson, Representative Wilson,
Yes.
Chair Elliott,
Aye. So with 14 yes votes, no votes, and 4 pass votes, House Bill 619 is reported with favorable expression. Congratulations. So the last bill on our agenda will be House Bill 286, an act relating to a word I could say in grade school, but I don't know if I can now. DNA. And this will be heard for discussion only. Representative Patrick Flannery is the sponsor. Deoxyribonucleic acid. Is that right?
That is correct, Mr. Chairman. I have a aunt that was a biology teacher, so I have maybe somewhat of an advantage on that, but it is deoxyribonucleic acid. Patrick Flannery, State Representative for the 96th District. This is a concept that was presented in the interim, and if you all attended that meeting or observed it, had a lady named Ashley Spence with the DNA Justice Project that participated by Zoom, filed this bill. I believe there is a committee sub. I don't know if we need to adopt that today because we're just doing this for informational purposes, but
we're not, but why don't you discuss it, if you would, the sub and the original bill and the...
I will, and hope to maybe alleviate whatever heartburn, answer any questions that folks may have on this. But the my purpose in this bill is to prevent future victims, to exonerate the innocent, and do justice. So all 50 states do DNA collection after a conviction. 33 states do it at the booking process. 19 of those do it for all felonies. This would, the original bill that was filed would have covered all felonies. The committee sub changes that to violent offenses as outlined in the current statutory scheme that we operate under. But very simply, what this does is it at the booking process, under the committee sub would collect it for those persons charged under violent offenses, and that information would be inputted into CODIS, which is the combined DNA index system that is ran nationwide. Many states are have jumped on board with this. Most recently, very large states like Texas, Florida does this, California, Colorado, and it is a very effective tool to have a successful prosecution of persons that are violent offenders, because oftentimes they are repeat offenders. I guess the negative feedback I get on this seems to be a privacy concern. I guess what I would say to that is, at the booking process, your mugshot is taken. After that, it's put in the newspaper. Oftentimes your name is run through the mud, even though you've not been convicted yet. You have a presumption of innocence. Your fingerprints are taken against your will. Someone actually from the government actually grabs your hand and takes your fingerprints, rubs it over an ink pad. And you're also subject to searches of your person, which can be very invasive. Your cavities could be searched. I think this is probably the least invasive of all those. And there's also a concern that somehow this DNA could be used against a person. What I have learned in this process, that's really not the case. There's over 3 billion markers in your DNA. 20 of this will go into CODIS, and if someone actually knew those numbers, it really does not mean anything to anyone. It couldn't be used against you, like maybe a Social Security number or a credit card system. But the courts have ruled this constitutional over 10 years ago, Maryland versus King. Under the federal system, this is currently used on criminal cases. So we're really not charting new ground or new water here, if you will. This is something that our sister states are using, the federal government uses, and I believe it, in my judgment, it's appropriate to do this to, as I said, prevent future victims, to do justice and exonerate the innocent. What better thing can you do to provide a solid defense when someone's got DNA proof that they were not the perpetrator? So I'd be glad to answer any questions, or that anyone, or open the floor for any comments.
Representative Kulkarni.
Thank you, Mr. Chair. I just had a quick question. Could you just repeat how many other states you had mentioned earlier already have laws like this on the books?
Okay. What I believe it's 33. I've also got some conflicting notes here that indicates 31, so it's in that 30 range. I feel very confident in saying that. But those states would collect for violent felony offenses. So the original bill that I had would include it for all, but the committee sub would limit it to violent offenses as currently outlined in KRS.
Thank you.
Thank you. Representative Nemus, you're recognized.
Thank you, Mr. Chairman. Just want to note, I know that you said the federal government does it in 33 states or however many do it. It's not a reason to do it, but it's at least comfort there. I was reading the committee sub, and I just want to make sure I understand this. This is only when somebody is charged with a violent offense, and if there is a dismissal or an acquittal, then the evidence is to be destroyed. Is that correct?
That's correct. Federal law currently guarantees the right to expungement if the arrestee is not ultimately convicted of the crime for which they were arrested. So I don't know that we would have to put that in our in this legislation, but I'm definitely not opposed to that. I think it's already covered under federal law, but and most of that would kind of govern CODIS, as I talked about before, which is kind of the database, if you will, of the DNA.
And Mr. Chairman, I would note that, upon arrest, people get fingerprints taken and a lot of other things as well. This has been challenged, and I think you said Maryland versus something?
Maryland versus King.
Can you send that out to all of us?
I can. The Supreme Court rendered that decision in 2013.
I believe Justice Kennedy called it the modern fingerprint in his majority opinion as to the DNA swabbing of someone charged. And in particular in Maryland, their law was at that time relegated to just serious violent felonies as well. Somebody else had a question. Representative Herron.
Thank you, Mr. Chair. I just want to clarify what what the exchange was between you and Representative Nemes. So are you saying that if cases are dismissed, that DNA is destroyed? Is that what you?
Federal law does that now, guarantees that. If this bill proceeds and someone wants to clarify that, I absolutely support that. I think it should be destroyed.
Just to follow up, is that done on an automatic basis, or does that individual have to do something to ensure that DNA is destroyed?
To my knowledge, it's done automatically, and I would support it being done automatically.
Okay, thank you.
Is there any other discussion? Representative Brancher.
So right now, if you're arrested, if your bill was, well, right now, and you're arrested for a violent crime, you don't have to give into a DNA sample?
That is correct. So at the booking process, you would they would take your photograph. They might do height, weight. They would do fingerprinting. You could potentially be subject, if there are reasonable grounds to do it, some sort of strip search. So all those things are done, which, I think most people believe that those are, necessary portions of a booking process and are reasonable. And I would argue that, taking something like a Q-tip and gently swabbing it, through the mouth is probably, less invasive than a strip search and other things that happen in the booking process.
Yeah, I guess I'm just confused on where the opposition is to this, especially if you're going to get rid of the records if you're if nothing becomes of it. So, that's my thought. Thank you.
Is there any other member seeking recognition? Any closing comments, Representative Flannery, that you have?
Mr. Chairman, appreciate you working with me on this. I know this is kind of a topic that we've discussed multiple times. Hopefully, I've alleviated any concerns. Willing to answer any questions after the committee meeting. Feel free to talk to me. Thank you all.
Thank you, and the committee will stand adjourned.